jungle.
So I was set to jump into the history of Fact-Finding 29, go over some of the nuances of the report, and address the vigorous competition piece that everybody's talking about. And then OSRA popped right back into the limelight. And well, let's talk Ocean Shipping Reform Act. That's OSRA. Hi, welcome to By Land and By Sea, an attorney breaking down the week in supply chain, presented by the Maritime Professor. That's me. I'm Lauren Beagen, founder of the Maritime Professor and Squall Strategies, and I'm your favorite maritime attorney. Join me every week as we walk through both ocean transport and surface transport topics in the wild world of supply chain. As always, the guidance here is general and for educational purposes only. It should not be construed to be legal advice, and there's no attorney-client privilege created by this video. If you need an attorney, contact an attorney. But before we get into the discussion of the day, let's go through my top 3 stories of the week. So story number 1, the U.S. Department of Transportation, DOT, Maritime Administration, MARAD, has announced the new members appointed to the Maritime Transportation System National Advisory Committee. So the 25-member committee is comprised of leaders from all facets of maritime, including commercial transportation firms, trade associations, state and local public entities, local labor organizations, academia, and environmental groups. So as a collective group, we will work with the Secretary of Transportation, Mayor, now Secretary Pete Buttigieg, with and through the new Maritime Administrator and retired Rear Admiral Ann Phillips, and we will advise on MTS, Maritime Transportation System policies, to ensure that the U.S. Maritime Transportation System can respond to continual increases in trade, as stated on the MARAD website. So yes, that's right. I said we. I am honored to have been appointed to this important 2-year term National Advisory Committee. So taken directly from the MTSNAC Charter, the objective of this committee is to identify and seek solutions to impediments hindering effective use of short sea transportation, which, let's stop there. Short sea transportation is essentially the maritime highways of the U.S. So that's using some of our internal waterways, that's using some of our coastwise shipping, that's using barging sometimes. So it's basically one benefit is taking some of the cargo and having it go through our waterways system to help alleviate some of the congestion on the roads where we can. But so that's a very short version of short sea shipping, which is also a tongue twister. So continuing here, the committee will provide information, advice, and recommendations to the U.S. Secretary of Transportation through the Maritime Administrator on matters relating to identifying and seeking solutions to impediments hindering the effective use of that short sea shipping or transportation. The committee is not going to be exercising program management responsibilities and is not actually going to be making decisions directly affecting the programs on which it's providing advice. So decisions directly affecting implementation of maritime policy will still remain with the administrator. These are just council roles. These are advisory roles. The administrator will use this advice, information, and recommendations generated by MTSNAC, so that's what the committee is, MTSNAC is the acronym, for an array of policy deliberations and for interagency discussions on meeting the goals and objectives. The Secretary and the Administrator, the Maritime Administrator, may accept or reject the recommendations made by MTSNAC and are actually not bound to pursue any recommendations that the MTSNAC does make. In the exercise of his or her discretion, the Secretary, the Administrator, and any of their designees may actually withdraw a task being considered by the MTSNAC at any time. So all of that to say, this is advisory in creation. This isn't the way that all these appointees are going to be making policy. The policy still resides with those political appointees, but it's really great to incorporate the industry in some of these decisions. So the charter outlines the description of duties too, and I'll read that directly here. So during the term of the charter, MTSNAC shall undertake information gathering activities, develop technical advice, and present recommendations to the administrator on short sea shipping matters, including how to address impediments hindering effective use of short sea transportation, including the expansion of America's marine highways, how to strengthen the U.S. maritime capabilities essential to national security and economic prosperity, ways to ensure the availability of a U.S. maritime workforce that will support the sea lift resources needs of the national security strategy, way to support enhancements of U.S. port infrastructure and performance, ways to enable maritime industry innovation and in information, automation, safety, environmental impact, and other areas. So the members are appointed solely for their personal members appointed solely for their personal expertise will serve as special government employees, and that's actually how I fit into the group. I'm excited here. I've said that I opened these companies because after moving up to New England, I missed the national conversation that I once had working in Washington, D.C. And I'm really excited to rejoin my friends and colleagues in D.C. And I'm really excited to meet new friends and colleagues across the nation as the other members of this committee and get to work on the important topics of the day, not least of which is short sea shipping, but also port infrastructure, which I've been a proponent of for many years. Look, funding ports, they are literally the point of entry of 90% of everything that we use. And that's where the ocean shipping, the vessel, obviously meets the shores. And we can't get that stuff here if we don't have effective ports. So a true investment in infrastructure of the ports, that's an investment I can get behind. So story number 2, big news here. The FMC, the Federal Maritime Commission, approved a $2 million settlement agreement with Hapag-Lloyd. So why does Hapag-Lloyd have to pay this money? They were found to be inappropriately charging detention and demurrage when no appointments were even available. Like, this is big. I'd even call this a marquee case of many more detention and demurrage cases to come. Like I told you, the FMC, the Federal Maritime Commission, isn't incredibly fast, but they are purposeful and they are thorough. And sometimes speed can be the thief of accuracy. And so they are just as concerned as the rest of us with unfair surcharges, and they're starting to clean it all up. They've been chipping away at the cases around detention and demurrage, making sure that they have charges that are fair. Remember, the FMC is responsible for the fair and efficient movement of goods via ocean-borne transport. And so it's that fair factor. That's what the FMC is starting to dive into. But you can't just willy-nilly call it fair. You need to systematically and methodically go through and define what is part of that fair. This announcement follows an initial decision by the Federal Maritime Commission's administrative law judge, so the ALJ. Essentially, the ALJ is the judge of first instance at the FMC. We talked about that when we talked about the FMC announcing and creating a webinar on how to file a complaint with the FMC. ALJs hear the formal complaints, and so that's what they are. They're the judge of first instance there, and they're independent from the rest of the agency in that they're supposed to be kind of in their own vacuum, analyzing the issues as they come in. And then that's when the FMC as a whole could sua sponte review. They could pull the case and decide to review the whole case on their own. So that's where the ALJ found that Hapag-Lloyd had violated the Shipping Act. So the FMC's Bureau of Enforcement, so that's a department within the FMC, brought the case after investigating the company. If you want to go look this up, this is docket 21-09. So unfortunately for the FMC, they're not actually going to see this money directly. This $2 million is going to get paid into the U.S. Department of Treasury, and it actually goes into the general fund. So in a sense, some agencies are able to recover that money and put it back into their operating account, and then, maybe hire more full-time employees, FTEs. In a sense, this almost makes the FMC more neutral because they're charging these civil penalties not for their own financial gain, but rather for the overall benefit of cleaning up the ocean shipping supply chain and their larger intention of clearing out the bad acting that's happening that we've all kind of talked about in the industry. So story number 3, Fact Finding 29 is already rolling out. This week, the FMC announced that they would be starting 3 initiatives directly taken from the 12 recommendations in the final report of Fact Finding 29. The ink hasn't even dried and they are moving. I love to see it. So these 3 new initiatives are establish a new and permanent international ocean shipping supply chain program. We talked about that. I'm not sure exactly what this will look like, but perhaps this will be a task force. Perhaps this will be a new office at the FMC. I'm interested to see what this looks like. Second initiative is reestablish the Export Rapid Response Team. And, we talked about this last week as being a former program where the FMC engages C-level, so CEOs of ocean carriers for the most part. And the participation has actually fallen off recently. And so that's what they want to do. The FMC intends to revive these efforts and revive that communication for Export Rapid Response Team. And the third initiative is take the steps necessary for carriers, marine terminal operators, and operating seaports to employ a designated FMC compliance officer. I'm going to say that again because I think that this is really important to take note, because this is going to be a new person that a lot of these places have to hire on or shift or create new responsibilities for. So take the steps necessary. That's what the FMC is going to do. For carriers, MTOs, marine terminal operators, ports essentially, and operating seaports, so the ports that don't that aren't landlord but that actually operate their ports themselves, to employ a designated FMC compliance officer. I talked about this last week. I think that's probably going to be a good thing, because that's where the FMC will have that go-to person. We'll have that person that not only understands the FMC regulations and the rules and what that entity is required to be complying with, but it's that person. It's somebody dedicated to that. So, like I said, pay attention to this last initiative. FMC compliance officers required at all carriers, MTOs, and operating seaports. This likely won't go into effect right away. This one will likely need a rulemaking, but the rulemaking could be a direct final rule. So, which that means essentially a non-controversial rule that's in line with the regulatory authority granted to the FMC through the congressionally created Shipping Act. So Congress created the Shipping Act, gave that delegated authority over to the FMC to interpret that and apply that out into the industry. And so that's what I think, is that this is going to be the FMC creating a rule saying we need this FMC compliance officer in all of these regulated entities that they've outlined. So, like I said, all this to say the FMC could draft a rule. They could give it 30 days for notice, or even potentially waive the notice and comment period and make it effective upon publication. I don't think that that's as likely. They don't want to pull a fast one. They just simply want compliance and better understanding of FMC regulations at all levels of the industry. They don't want to belabor the whole process because, maybe it might be a little bit difficult to hire on that FMC compliance person. Maybe you're not hiring somebody new. Maybe it's just shifting over. Honestly, you should have been on top of this anyways. You should have somebody in your world who knows FMC compliance, because you're regulated by them. And so I think that that's maybe what we'll see, is maybe co-branding of somebody who's in charge of maybe the federal regulatory or just regulatory compliance in general. But I do want to point out one thing. The press release that the FMC released didn't mince words. So the FMC reiterated that Shipping Act requirements are not optional. And the news release said the following: one of the two most common complaints Commissioner Dye heard throughout her work leading Fact Finding 29 was the excessive amounts of demurrage and detention fees shippers and truckers were charged, despite the Commission having issued a rule on this matter in March 2020. Compliance with Commission regulations and the statutes it administers is not voluntary or discretionary. Ocean carriers, marine terminal operators, and operating seaports designating an FMC compliance officer who reports directly to the senior-most U.S.-based executive will aid in ensuring an industry-wide observance of legal and regulatory requirements. So I'm going to go back to that. The FMC is basically saying, we put out a rule in March 2020 that talked about reasonableness, that talked about kind of best practices associated with detention and demurrage. So even if they haven't gotten to the bad acting, even if the FMC hasn't gone through the whole gamut yet, just because something may have been non-compliant or a direct violation of the Shipping Act doesn't mean they're not going to find it. I keep saying this. They're not super fast. They can be pretty quick, but they're methodical. They're going through it systematically. They're not going to forget this stuff. They're not going to lose it. They're going to be going through and making sure that they're cleaning this all up. And so if there are violations of the Shipping Act or the regulations, they're going to find it and they're going to go after it. Just because you might have skirted through doesn't mean that you've skirted through forever. Man, that was just the intro. Let's go, folks. OSRA. So let's get into the meat and potatoes of the day. So what's going on here? This week, I was alerted to some breaking news by a friend in DC about the two bills. So the House bill and the Senate bill. And remember, this is the Ocean Shipping Reform Act. So this was previously done in 1998. There was an Ocean Shipping Reform Act, which is essentially, it was a modification of the original Shipping Act. And so now there's been OSRA 21 and 22 going through, the House bill and the Senate bill. And these bills have been stuck in committee. So the House bill was passed through full House. The Senate bill was passed through full House. Then it goes to a committee and they try to synthesize the two bills because they were a little bit different. And then ultimately that committee will then send it to the president. And that's what we were all waiting for. The committee had been meeting, or so we heard, and that they were going to try to figure out a way to bring these two bills together so that they could send it up to the president for his signature. Look, we heard that this has been stuck in committee, but it was finally starting to break free. Just yesterday, we heard that the Senate bill had won the duel and was being sent to the House for clean approval. So let me say that again. The Senate bill, there was a House bill and a Senate bill. What we heard is that the Senate bill has won that duel and is now being sent over to the House as it is, as it was approved by the Senate for a clean approval with the House. So if they have two fully voted on, fully approved bills that originated in the Senate, that can go up to the president right away. And I'm hopeful that maybe that's what's going to happen here. So this actually lined up, it was a tip. It was from a friend in DC saying, this is what I anticipate to happen. This is lined up with the activities of the president's office that we saw yesterday, where they released a video of the president talking with shippers, with beneficial cargo owners, about the exponential increase in ocean shipping rates. And today, the president is set to make a speech at the Port of Los Angeles. So what does all this mean? Let's break it down. So I covered OSRA, the Ocean Shipping Reform Act, and the two bills in my March 25th By Land and By Sea episode. I've linked it, and I'll link it again in the notes here. But that was like 3 months ago. And it seemed like a great time for a refresh to see if anything has changed. So as a reminder, these videos live on my YouTube page. It's By Land and By Sea. But, I'm actually considering maybe migrating them over to a podcast. I'd love to hear your feedback on that. If you think that it would be valuable, I've received feedback that it might actually be more valuable for cataloging and being able to search among previous recordings. What do you think? I'd love to hear. I'm just about ready to pull the trigger on that, but I'd love to hear if you think it would be valuable. I'll probably do it faster. I'm still learning how all of this works. So let's get back to it. So the Ocean Shipping Reform Act. So there are two bills that have been voted and approved, a House bill and a Senate bill, like I said. So the House took up the issue first. So Congressman John Garamendi, a Democrat from California, and Dusty Johnson, a Republican from South Dakota, introduced H.R. 4996. Ocean Shipping Reform Act of 2021. It was introduced August 10th, 2021, and by December 8th, 2021, had been passed by the House. It was passed 364 to 60. Now that's a big margin. It was approved through actually a procedural maneuver without the traditional hearing or markup, which, kind of made it look like it was being rushed through, but it wasn't necessarily. Other than it was a show of Congress, they wanted to show they were doing something. So recall back to the end of summer and edging into fall. And this was just this past summer and fall. Remember, everybody was afraid Santa wouldn't show up this year because of how absolutely chaotic the supply chain was. Crazy numbers of vessel offshore, LA Long Beach, ocean freight rates through the roof. And. There was a lot going on. So the House passed a bill. But what was in that bill? Look, I'm not going to get political about all this, but I just don't see how the majority of congressmen were actually able to either read the whole bill and or understand the whole bill. This is complex stuff with a lot of nuances, and trying to quick fix the system. I don't know. I've said this before. I prefer Congress to have a little more evergreenness to their actions regarding supply chain and ocean shipping. And we'll talk about this in a minute, but the 1998 OSRA bill took 8 years of discussion. And so this, while it had been a few years of being in the COVID, congestion, supply chain crunch, it wasn't 8 years by any means. And there was a lot happening, so there was certainly something to be said for the expediency. But it just all felt a little fast. So the House bill, in my opinion, had some issues, and I'm going to go further and say that there were actually some big issues in the bill, issues that definitely should have had some debate, requiring carriers to load exports. Let me say that again. It required carriers to load exports and take on exports. It's one thing if it hinges on no unreasonable denials of exports or saying, you can't just outright not take them. But it was saying this was the government requiring businesses to engage in business, in this taking of the export, that up until a few years ago, that might have been causing that business to operate at a loss. So remember, up until really 5 years ago, ocean carriers barely broke even in the ocean freight industry. These billion-dollar profits are a shock to no one more than ocean carriers. They were barely breaking even. So, at the very least, this seemed like something that should have had a little more discussion, right? So the House version passed, and in the bill summary, it explained that the bill also included a few other things. So the House bill was going to require ocean common carriers to report to the FMC each calendar quarter on total imports and export tonnage and the total loaded and empty 20-foot equivalent units. So we've talked about this. So a cargo box, the over-the-road boxes are 53 foot for the most part. So what we're seeing here, what we're talking about here for ocean cargo movement is a 20-foot box, which is a shorter box. I mean, roughly just under half of what you might see on the road. When you go to a port, what you're going to see most times is a 40-foot equivalent unit, which is similar, not quite as long, obviously, 40 versus 53. But the way that we still measure cargo boxes on a container or on a vessel is by the 20-foot equivalent unit. So that's when we talk about TEUs. So we might say a vessel has 20,000 TEUs. Like I said, if you think about it, you're probably thinking about the 40-foot equivalent unit, which is, 20,000 TEUs. I mean, these are crazy numbers anyways, but 20,000 TEUs is probably more like 10,000 TEUs, if your mind is that accurate in kind of trying to identify how many, cargo boxes are on this container or are on this vessel. But so that's just a little kind of 101 on how we kind of talk about these 20-foot equivalent units, these cargo boxes. So, I mean, look, the FMC can actually request this information, but this makes it a direct reporting requirement. That's not bad. Requires the FMC to publish and annually update all of its findings of false certifications by ocean common carriers or MTOs, marine terminal operators, essentially ports, and all penalties assessed against such carriers or operators. I don't mind this. Visibility is probably a good thing. So this was all part of the House bill, remember. So it also would have prohibited ocean common carriers and marine terminal operators from retaliating or discriminating against shippers because such shippers have patronized another carrier or filed a complaint. This is already kind of one of the authorities of the FMC, but I love the reiteration. We should not be penalizing. We should be going after people who retaliate or discriminate against shippers because they've decided to take a different route. This House bill would have directed the FMC to establish rules prohibiting ocean common carriers and MTOs from adopting and applying unjust and unreasonable demurrage and detention fees. This was already in the works, Commissioner Dye's work, and through the open rulemaking. So that was the House bill. It was more prescriptive. It was more targeted, more controlling in its regulations. Could be good, but that's what the FMC is for, I argue, to have the industry interpretation of the statutes that are voted on by Congress and to interpret Congress's intentions and have them make sense for the industry. So let me say that again. Congress votes, they create the statute. I like it when the agency, the FMC in this instance, can then interpret what Congress's intentions are and create regulations. And when they do that, regulations are created through rulemakings. And as we've found out recently, if you didn't already know, there's a comment period that's associated with most rulemakings. And that's your opportunity to engage with the agency. That's your opportunity to have your voice heard. When it comes down from Congress directly, yes, we voted those people in, but there's less of a targeted response moment where the people can weigh in. It seemed like instead of the intention being voted on and the application being given to the FMC, the House wanted to clearly define the application. So if the FMC defined the application, that would likely include, like I said, a notice and comment period, which means you and I, as the American public, can weigh in via comments. So that was a House bill. Looks like the House bill might be done. So let's talk about the Senate bill, because that's what we've heard recently, is that the Senate bill has won out. There was kind of a duel, which one was going to win out, which pieces of which was going to win out. So now we've heard the Senate bill will be heading over to the House probably as quickly as next week, maybe, for their vote and approval. And if they pass it, then it goes to the president for his signature. So we went from maybe the end of the summer, maybe we'll have something from OSRA, to maybe next week, we might be diving right into infrastructure, port development, ocean shipping reform. We might be diving into all sorts of, I say we might be diving into all of it. It might be a ticker on the mainstream media. Hopefully it's going to be more than that. I'm looking forward to seeing this on 60 Minutes again. But so here we go. So the Senate bill. The bill's been discussed informally in the Senate since the House bill was released, but formally it was introduced February 3rd, 2022, just about 4 months ago, by Senator Klobuchar, a Democrat from Minnesota, and Senator John Thune, a Republican from South Dakota. It was introduced in the U.S. Senate Committee on Commerce, Science, and Transportation, and then voted out of committee March 22nd, 2022. So about 6 weeks later. And then a week later, it passed the full Senate. So when I previously covered these bills a few days after the Senate version had passed committee, but before it went to the full Senate vote, I liked the Senate version more, comparing Senate to House. I thought it provided deference to the FMC to be the regulator. Instead of Congress in a quick fashion trying to take control, the FMC is obviously the agency directly responsible for the regulation over the industry. And so therefore their whole creation is to be a little bit more of an expert in this area. So what does the Senate bill do for the industry? It prohibits ocean carriers from unreasonably, let me say that again, unreasonably denying exports. So we talked about the not allowing or requiring businesses to take exports. Now it's flipping that and saying it prohibits ocean carriers from unreasonably denying those exports. So if they're saying, I'm not taking exports today, you can go after them. But if they're saying, I can't take exports, I just can't, and there's a good business reason, I'm not sure what that would be, but if there's a good business reason for that, okay. So now unreasonable is a subjective term that does need definition. So it also requires that the FMC create a rulemaking determining what unreasonably denying exports looks like. But, I like rulemakings. I think that they're important. And like I said, you get that back and forth. You get that opportunity for comment. A little administrative law explanation. The Senate makes the statutes. We kind of just talked about this. These give authorities to federal agencies like the FMC, and then the federal agencies make the regulations from those statutes. They interpret the statute, and then they make the regulation. So the statutes are the U.S. Code, and the regs are the CFR, the Code of Federal Regulations. So if you ever see kind of a citation and it says USC versus CFR, USC came from Congress for the most part, and CFR came from an agency, in this case, likely the FMC. So the language says, not later than 1 year after the date of enactment of this act, the Federal Maritime Commission shall issue rulemaking defining unreasonable refusal to deal or negotiate with respect to vessel space. It also shifts the burden regarding the reasonableness of detention and demurrage from the invoice party to the ocean carrier. The Senate bill would now require the ocean carrier to prove that it was reasonable to assess the charges instead of the cargo owner. So this Senate version mimics the House version for reporting requirements. Ocean common carriers to report to the FMC each calendar quarter on total import exports to EUs. I like this. I like visibility. The FMC already monitors this, but the reporting requirement, look, not essentially how cargo boxes, like I said, TEUs is what they're going to be reporting on, the import-export tonnage of TEUs. It would also authorize the FMC to self-initiate investigations of ocean common carriers' business practices and take enforcement action as appropriate. Arguably, they kind of have that authority, but it's great to reinforce it. The Bureau of Enforcement can certainly do that. This would also add a section on registering shipping exchanges. So this is going to be, I mentioned this in March when we covered it, this is going to be an interesting area to continue to watch. It's going to create an entirely new part in the U.S. Code, Chapter 405, Shipping Exchange Registry. The text says, in general, no person may operate a shipping exchange involving ocean transportation in the foreign commerce of the United States unless the shipping exchange is registered as a national shipping exchange under the terms and conditions provided in the section and the regulations issued pursuant to the section. This is going to be interesting. So where are the lines here? Will this include freight portals that digitization is moving toward? Will this include marketplaces that pass along the freight information? So the text of the proposal, this has been changed a little bit. Definition of shipping exchange. In this section, the term shipping exchange means a platform. This is new. In parentheses, it says digital, over-the-counter, or otherwise. A platform that is digital, over-the-counter, or otherwise, that connects shippers with common carriers for the purpose of entering into underlying agreements or contracts for the transport of cargo by vessel or other modes of transportation. Like I said, this language was updated since I last talked about it. It now includes the digital, over-the-counter, or otherwise language. Interesting. I like that it's gotten a little bit more clear. The Senate version also directly discusses detention and demurrage invoice information. I was looking back. This, I think, is new, or maybe I missed it before, but this is very detailed. And I don't recall seeing this before, but this section has detention and demurrage invoicing requirements as identifying what contents need to be in an invoice. So an invoice, unless otherwise determined by commission rulemaking, shall include accurate information on each of the following, as well as minimum information as determined by the commission. So there's already that rulemaking for billing practices and what needs minimum billing practices that the FMC rulemaking covers. But Congress is weighing in here. The Senate version, the Senate bill here says, so what needs to be included? The date that the container is made available, the port of discharge. So remember, right now, there are really no requirements. You could issue an invoice for detention and demurrage that just says $3,000 6 months ago. Like, $3,000 for what? Well, the container. Well, which container? It's not on the invoice. Who do I call? I get this invoice. I don't even know who has been sent this invoice. So there might be 3 or 4 people that just pay it because they're thinking, oh, this is probably for me. When really maybe it's essentially a CC invoice versus the person who actually is responsible for payment. So I love to see a little bit more prescriptiveness here. And I love to see that whoever it is saying, here's some minimum stuff that we really need to get control of. So Senate version says, date that the container is made available, port of discharge, container number or numbers, if there's multiple containers. For exported shipments, the earliest return date, the allowed free time in days, the start date of the free time, the end date of the free time, the applicable detention or demurrage rule on which the daily rate is based. So you can reference that back and find the amount, the applicable rate or rates per the applicable rule. So not only the rule, where it is, but how much are you actually supposed to be charging? I mean, it's a gut check. It's a way of kind of making sure that this is accurate. The total amount due, obviously, that's probably the only thing that all these invoices had. The email, telephone number, or other appropriate contact information for questions or requests for mitigation of fees. And so this is going to be important. This is that dispute resolution. This is if you get an invoice and you're like, what is this for? I need some more information. An email, a telephone number, or some sort of contact information for questions or requests. A person, a specific way to get in touch with the issuer of the invoice. That's great. A statement that the charges are consistent with any FMC rules with respect to detention and demurrage. This is interesting. So this is requiring on that invoice a statement that the charges are consistent with any FMC commission rules with respect to detention and demurrage. This is saying that they have to essentially hold up their right hand and say, this is in compliance. It's pretty interesting. Maybe it'll gut check the invoice generation. Continuing on, a statement that the common carrier's performance did not cause or contribute to the underlying invoice charges. A statement that the common carrier's performance did not cause or contribute to the underlying invoice charges. Again, that's kind of raising your right hand saying, this detention and demurrage bill is not larger because of my fault. I kind of like these statements. They're going to gut check the invoice generation. I'm not sure that I actually love that Congress is the one mandating this level of specificity through a bill, but I do love the attention to detail here. This tells me that the Senate drafters and the amenders were doing their homework. They were digging into the root of the causes, particularly detention and demurrage. The mention of the start date of free time, the end date of free time, the applicable detention and demurrage rule on which the daily rate is based, this all shows that they are starting to understand how this part of it works. And that's great. The Senate bill also has 3 rulemakings that it requires. So the first being a rulemaking on detention and demurrage. So not later than 45 days after the date of enactment of this act, it's requiring the FMC to initiate a rulemaking further defining prohibited practices by common carriers, MTOs, shippers, ocean transportation intermediaries regarding the assessment of detention and demurrage. This rulemaking is kind of already in the works. But it also says the FMC shall issue a final rule defining such practices not later than 1 year after the date of enactment. So it's initiating rulemaking further defining prohibited practices by common carriers and the associated regulated entities. This is a little different than the billing rulemaking that's going through right now. So a little bit different. Maybe there's going to be a new rulemaking here. It's going to be, I don't know, it's probably going to be more general than what Congress is intending, because I think that the case law is really going to dive into those specific fact-by-fact prohibited practices. But this will be interesting to see the first crack that the FMC comes up with. Senate also shows that they've done their homework again by further clarifying that the rules they're requiring is only to further clarify reasonable rules and practices related to the FMC's interpretive rule on detention and demurrage of May 18, 2020, the very same one that news release was mentioning. So, contents. So the rule shall only seek to further clarify reasonable rules and practices relating to the assessment of detention and demurrage. This is still relating to that first rulemaking. To identify and address the issues identified in the final rule published on May 18, 2020. The Senate bill also talks about another rulemaking, a rulemaking on unfair or unjustly discriminatory methods. So not later than 60 days. That first one was 45, 60 days. They're going to give them an extra 15 days here from the enactment. Initiate a rulemaking defining unfair or unjustly discriminatory methods. Now, this is going to be interesting. This is a very, there's probably some clear low-hanging fruit here, but this is tough, defining unfair or unjustly discriminatory methods. I think this is going to be another general rulemaking that I think case law will further define, because you don't want to, in a quick fashion, in 60 days from the enactment of this act, have something that's too restrictive. You don't want to have unintended consequences by a rulemaking. But I'll be looking for this one. This is going to have a notice and comment period as well. I think we're all keyed in now, and we're all kind of watching some of these rulemakings. The third rulemaking is rulemaking on unreasonable refusal to deal or negotiate with respect to vessel space accommodations. This is what we were talking about. This is the unreasonable to take exports. So this is unreasonable refusal to deal or negotiate with respect to vessel space accommodation. So not later than 30 days after the date of enactment. So this will be the first one, 30 days after the date of the enactment. The FMC, in consultation with the Commandant of the U.S. Coast Guard, shall initiate a rulemaking defining unreasonable refusal to deal or negotiate with respect to vessel space. The FMC shall issue a final rule not later than 6 months after the date of enactment of this act. This one's going to move quick. We've got to watch this, because 6 months, a final rule needs to come about 6 months after creation. So we're looking at, by Christmas, by the turn of the new year, we're going to have a full rule on unreasonable refusal to deal or negotiate with respect to vessel space accommodations. These have some quick turnarounds, 30, 45, 60. The FMC is going to be busy. So all I really have to say to that is I hope that the OSRA bill comes with some money. They're going to need some extra people. There's also a section on public input on information sharing, stating public input on information sharing not later than 60 days after the date of enactment of this act. The FMC shall issue a request for information seeking public comment regarding whether congestion of the carriage of goods has created an emergency situation of a magnitude such that there exists a substantial and adverse effect on the competitiveness and reliability of the international ocean transportation system. It's kind of a catch-all. Basically, they're saying, is congestion of carriage of goods creating an emergency situation? Weigh in, tell us what's going on. And then second to that, whether an emergency order under this section would alleviate such an emergency situation. And third, the appropriate scope of such an emergency order, if applicable. This is going to be it. This is going to be the catch-all. This is where you can start filing your comments, start getting your thoughts together on what you think has been the hardest area of this emergency of, during the pandemic and just recently with the congestion of the carriage of goods. During the public comment period under this rule, under this new initiative from the Senate, the Commission may consult, as the Commission determines to be appropriate, other federal departments and agencies and persons with expertise relating to maritime and freight operations. So there's a section on emergency orders requiring information sharing. This is also kind of tagging onto that. On making unanimous determinations described above, the Commission may issue an emergency order requiring any common carrier or marine terminal operator to share directly with relevant shippers, rail carriers, or motor carrier information relating to cargo throughput and availability in order to ensure the efficient transportation, loading, and unloading of cargo to or from. And this is for inland destinations or points of origin, any vessel, or any point on a wharf or terminal. This one, I'm interested to see how this plays out. There are some exceptions allowed here. So common carrier or MTO, subject to an emergency order issued pursuant to this section, may submit to the Commission a petition for exemption from one or more requirements of this, if it were an emergency order, based on a showing of undue hardship or other condition rendering compliance with such a requirement impractical. So what they're trying to do here is they're trying to really kind of force the hand of information sharing. But they're saying, we don't want to do it so that you have a business undue hardship or other condition rendering compliance impractical. But they want to say, just because you don't want to, that's not going to be good enough. You need to show us why you can't or why you shouldn't be forced to do so. There's also a section on chassis pools now. So again, chassis are basically, so the cargo boxes that are on an ocean carrier don't have wheels. And so then they have to be put on a chassis that has wheels. So no later than April 1st, 2023, the FMC shall enter into an agreement with the Transportation Research Board And they're going to be carrying out a study and develop best practices for on-terminal or near-terminal chassis pools that provide service to MTOs, motor carriers, railroads, and other stakeholders. They're really trying to figure out supply chain efficiency and effectiveness and get a conceptual control and really kind of understand more what's going on with these chassis pools. So look, for my surface transport people, OSRA is for you. The Ocean Shipping Reform Act has some surface transport stuff. There's a section on license testing through the FMCSA, different than the FMC, the FMCSA, the Federal Motor Carrier Safety Administration. So not later than 90 days after the date of enactment of this act, the administrator of the FMCSA, referred to in this section as administrator, shall conduct a review of the discretionary waiver authority described in the document issued by the administrator entitled Waiver for States Concerning Third-Party CDL Skills Test Examiners in Response to the COVID-19 Emergency. I'm sure this is going to be talked about a lot on the surface transportation side, and I'm interested to see, what comes of this. Safety concerns. I'm going to be watching this. It's interesting that this got tagged in to the ocean shipping OSRA bill, but I like that it's kind of a total picture, because that's what we're all moving toward, is breaking down the silos of the supply chain, making sure that both by land and by sea is covered. Digitization has found its way into this Senate version, a report on adoption of U.S. technology at U.S. ports. I usually say if the DOS operating system is still in use somewhere, I would expect it to be at a port. Ports are notoriously out of date on their basic technological advances. Not all ports, but I support this. Imagine if container yards had Wi-Fi and you could access the port network while on the yard. Yes, this is something that isn't in place in a lot of these ports. Wi-Fi. That's the level we're talking about here. Being able to have an iPad or your phone or whatever, and being able to be out on the yard and having some of that technology built in. So this will be a report on adoption of technology at U.S. ports. Not later than 1 year after the date of this enactment, this report is going to be submitted to Congress describing the adoption of technology at U.S. ports. And because I've been so worried about the funding, they also addressed funding of appropriations, and they've increased some of these appropriation levels. They said striking just over 29 million for fiscal year 2020 and just over 29.6 for fiscal year 2021, and inserting 32.8 million for fiscal year 2022. 38.2 for fiscal year 2023, 43 million for fiscal year 2024, and 49.2 million for fiscal year 2025. So, previously I joined the critiques that said the bill was supposed to address congestion at the port, but I think the version that the Senate has come out with now, that's voted on by the full Senate, did add a lot to that to qualm some of those critiques. It attempts to get at the problem from different angles: chassis pools, tech at ports, surcharges, and detention and demurrage invoicing. I like the diversity of solutions presented by this bill. Formerly, my biggest issue was that there was no discussion of an increase in full-time staff at the FMC to take on these additional roles, but this bill requires a 7% increase for the FMC in different areas. Look, it's not a lot, but with only 120 people, 7 people is going to make a difference. And it's not quite clear if it's 7 people per office, 7 people minimum per office. That office can't lower than 7 people. But look, with 120 people roughly is what the FMC says. And I'm not exactly sure what their full-time employee authorization is now. It's right around there. But in the budget request hearing where Chairman Dan Maffei gave his testimony, he said that with an increased budget allowance, he could staff the commission at 150 full-time employees, or FTEs. Imagine. And most of those roles would be enforcement and consumer assistance, Chairman Maffei said. That's great. So why did I go so in depth on the Senate version? Because like I said, in the duel of the House versus the Senate seems to have won. And I have it on good authority that next week the Senate bill will go to the House for a vote. If that happens, like I said, if the House approves the bill, since it's the same version now that's been approved by both chambers, if it passes the House, it's likely going to go to the president for signature. And I think that it would get signed very quickly. I think that that's why we've seen a lot of buzz, especially from the administration, in the past 2 days, 48 hours really, on ocean shipping, because I think that they're getting ready, because next week there might be some movement. Phew, I had intended on diving into OSRA 98 today. So that's the Ocean Shipping Reform Act of 1998. But the new details about the Senate bill took up all of our time, and we're well past our usual half an hour. I still think that I have it on my list, though, a historical look at OSRA 98, This isn't the first time an Ocean Shipping Reform Act has been passed through, but like I said, the last time took over 8 years to finalize the language. I hope you enjoyed the discussion today. I hope this helps you feel empowered going into next week, where I'm almost confident. I'm pretty confident. I think we're going to see some movement next week on OSRA 22. And this way, if you've watched this or listened to this, you're going to be prepared to have those conversations saying, I knew this was going to happen because I was listening to the Maritime Professor. As always, the guidance here is general for educational purposes. It should not be construed to be legal advice directly related to your matter. If you need an attorney, contact an attorney. But if you have specific legal questions, feel free to reach out to me at my legal company, Squall Strategies. Otherwise, for the non-legal questions, for e-learning, general industry information and insights, come find me at the Maritime Professor. If you like these videos, let me know. Comment, like, and share. If you missed any previous videos, these videos live on my YouTube page, By Land and by Sea, presented by the Maritime Professor. And while you're at it, check out our website, themaritimeprofessor.com. And maybe stay tuned. Maybe this will become a podcast. So until next week, this is Lauren Beagen, the Maritime Professor, and you've just listened to By Land and by Sea. See you next time.